3 years ago, a couple spent nearly $1 million building what they proudly called their forever home in the countryside. 8 months later, a judge ordered them to hand over more than $100,000 because a portion of that dream home was sitting on land they never owned in the first place. The crazy part wasn't that they made a mistake. People make mistakes all the time. The crazy part was that I warned them repeatedly while they still had a chance to fix it, and every single time they acted like I was the problem. My name is Ethan Parker, and my family owns a narrow 5-acre strip of land out in rural Missouri. My dad bought it back in the late 80s when nobody wanted property this far from town. It's not some glamorous ranch or luxury estate. It's mostly trees, a dirt access road, a creek running through the back section, and enough privacy that you can sit outside at night and hear nothing but frogs and wind moving through the branches. The land isn't valuable because of what sits on it. It's valuable because it's ours. Every property corner was professionally surveyed decades ago. The iron markers were still in place. The county records matched perfectly. There was never any confusion about where my land ended and where the neighboring parcel began. Then the new neighbors arrived. Their names were Ryan and Madison Keller. They came from Portland after deciding they were tired of city life. At least that's what they told everyone online. Their social media pages were full of videos about escaping the rat race, embracing nature, building a self-sufficient lifestyle, all the usual stuff people post when they're trying to reinvent themselves. They bought the 5 acres next to mine and immediately hired architects, engineers, contractors, landscapers, the whole package. Within weeks, heavy equipment was rolling through the property every morning. Concrete trucks came and went. Excavators carved through the hillside. Framing crews worked from sunrise until dark. It was obvious they weren't building a modest country cabin. They were building a statement piece. At first I didn't care. Their land was their business. Then one afternoon while I was checking fence lines after a storm, something caught my attention. The corner of their foundation looked unusually close to the property boundary. Not a little close. Uncomfortably close. I remember standing there staring at it for several minutes, trying to convince myself I was imagining things. Maybe it was the angle. Maybe the excavation made everything look different. But the more I looked, the more my gut told me something wasn't right. So I walked over to one of the original survey markers. The iron stake was exactly where it had always been. Half buried, rusty, untouched. Then I stretched a tape measure. My stomach dropped. Their concrete foundation wasn't near the property line. It was over it. Not by several feet. Not by a dramatic amount. Just a few inches. Around 6 inches. That's it. 6 inches. The kind of distance most people would step over without noticing. But legally, 6 inches might as well have been 6 miles. I found Ryan standing near a stack of lumber reviewing plans with a contractor. I walked over calmly and explained what I found. He looked at me like I had interrupted something important. I pointed toward the survey marker and explained that part of the foundation had crossed onto my land. Instead of looking concerned, he actually laughed. Then he pulled out his phone and opened one of those property map apps people use while hiking. He zoomed in and said, "See? According to this, we're fine." I honestly thought he was joking. I told him those apps can be off by 10 or 15 feet depending on signal conditions. I explained that survey markers and recorded plats were what mattered. Ryan shrugged and said maybe the old markers had shifted over the years. Shifted. Like an iron stake driven deep into the ground somehow wandered 6 inches on its own. That was the first moment I realized this wasn't going to be a simple conversation. A week later I tried again. This time I brought copies of both property surveys. I highlighted the measurements. I showed him exactly where the overlap occurred. He barely glanced at the paperwork. Construction had already progressed significantly, and I could see the calculation happening in his head. He wasn't evaluating whether I was right. He was evaluating how expensive it would be to admit I was right. Finally, he said something that told me everything I needed to know. He suggested we simply adjust the property line. Just move it. On paper. As if property ownership worked like dragging a line across a phone screen. Then he offered me $1,000 for the inconvenience. $1,000. That's what he thought my property rights were worth. I told him absolutely not. I said the foundation needed to be corrected before construction went any further. His expression changed immediately. The polite smile disappeared. He said I was being unreasonable. I said no, I was being a landowner. He shook his head, turned around, and walked away. Construction continued the next morning like our conversation had never happened. standing there watching crews pour more money into a house that was partially sitting on my land, I realized something important. They weren't confused anymore. They weren't mistaken anymore. They had been warned. They knew exactly what the problem was, and they had made a deliberate decision to ignore it. Now, before I continue with what happened next, let me explain why situations like this become disasters so fast. A lot of people hear 6 inches and immediately think, come on, that's basically nothing. But according to standard procedure, property boundaries are treated as exact legal lines, not rough suggestions. It doesn't matter whether someone crosses by 6 inches or 6 feet. Once part of a permanent structure sits on land owned by somebody else, the issue becomes much bigger than the physical distance involved. From a legal perspective, courts often look at whether the builder had notice of the problem and whether they had opportunities to correct it. That's where Ryan's situation started getting dangerous. He wasn't dealing with an accidental discovery after construction was complete. He was being warned while the project was still underway. And honestly, this is a psychological trap a lot of people fall into. Once they've invested hundreds of thousands of dollars into a project, admitting a mistake feels more painful than doubling down on it. Their brain starts protecting the investment instead of solving the problem. The lesson here is simple. The earlier you fix a mistake, the cheaper it usually is. Ignore it long enough, and eventually a judge may decide the price for you. About 2 weeks after that second conversation, I hired an attorney. Not because I wanted a fight, and definitely not because I thought I was about to become rich from 6 inches of dirt, but because I could already see where this was heading. Every day the house got bigger. Every day the mistake became more expensive to fix. My attorney sent a formal demand letter explaining the encroachment, documenting my previous warnings, and requesting that construction stop until the issue was resolved. The response arrived about 10 days later. I'll never forget reading it. Their attorney argued that the encroachment was minimal, caused no measurable harm, and that requiring demolition would be excessive. In other words, they admitted the problem existed but wanted everyone to pretend it wasn't important. Then came the first real offer. They wanted to pay me $5,000 in exchange for a permanent easement. $5,000 to legalize a mistake they had knowingly continued after multiple warnings. I declined immediately. The next week we filed suit. Once the lawsuit started, something strange happened. Ryan and Madison became even more confident. Instead of slowing down construction, they accelerated it. New trucks arrived almost daily. Landscaping crews appeared. Stonework was installed. Outdoor lighting went in. Expensive decorative fencing surrounded the property. It was like they believed that if they finished the house fast enough, reality would eventually surrender. Every few days Madison posted glamorous updates online. There were drone shots showing the roofline against the sunset. Videos of custom kitchen installations. Captions about building a dream lifestyle. Thousands of likes. Hundreds of comments. People kept writing things like living the dream and goals. Every time I saw those posts, I almost laughed because nobody outside the courtroom knew that a legal time bomb was ticking underneath one corner of that beautiful house. Meanwhile, my attorney wasn't interested in social media. He was interested in evidence. We gathered county records, survey reports, historical plats, construction timelines, copies of every communication, photos showing the survey markers, photos showing the foundation crossing the line, documentation proving they had been warned before major construction milestones. The case wasn't complicated. It was just thorough. The months rolled by. Depositions began. That's where things got interesting. During one deposition, Ryan tried to explain that he genuinely believed the property app was accurate. Unfortunately for him, contractors, surveyors, and engineers testified that mobile property apps are not substitutes for professional surveys. Then came another problem. One of the contractors confirmed that concerns about the property line had been raised during construction. Not formally, not dramatically, but enough that people on site were aware there might be an issue. Suddenly, the narrative shifted. This wasn't an innocent misunderstanding anymore. It looked more like a conscious decision to keep building despite uncertainty. That's a very different story in a courtroom. By the 6th month, the house was completely finished. It was gorgeous, honestly. Massive windows, custom stone exterior, covered porch, detached workshop. Everything you'd expect from a luxury rural home. Friends and family visited regularly. Their social media followers praised every update. From the outside, they appeared to have won. But legal cases don't care about appearances. Legal cases care about facts. 8 months after filing, we finally reached the hearing that would determine the outcome. The courtroom wasn't packed with spectators or television cameras. It was just lawyers, documents, experts, and a judge who had clearly seen property disputes before. Our surveyor testified first. He walked through measurements, markers, records, and boundary verification. Everything was precise. Everything was documented. Their survey consultant tried to challenge portions of the findings, but couldn't eliminate the central fact. Part of the structure occupied my land. Then came testimony regarding notice. This turned out to be the most damaging part of their defense. The judge reviewed evidence showing multiple warnings, personal conversations, survey documents, attorney correspondence. The timeline painted a very clear picture. They didn't discover the issue after construction. They discovered it during construction and chose not to act. That's a distinction judges tend to take seriously. I remember watching Ryan's face while the evidence was discussed. For the first time since this whole thing started, he looked nervous. Not annoyed. Not confident. Nervous. Madison sat beside him quietly taking notes, occasionally whispering to their attorney. The hearing lasted most of the day. Then everyone waited. Several weeks later, the ruling arrived. I'll be honest. Even I was surprised by how direct the judge was. The ruling stated that the encroachment resulted from deliberate negligence. Not because they intentionally set out to steal land, but because they consciously ignored repeated warnings that would have allowed correction before completion. That language mattered. A lot. Then the financial discussion began. The court-appointed appraiser evaluated the circumstances and considered several factors. The encroachment involved land essential to the legal status of the structure. The homeowners had continued construction despite notice. The burden of resolving the issue should not fall on the innocent property owner. The valuation came back at $75,000. When my attorney first explained the figure, I thought he was joking. But he wasn't. The court provided two options. Option 1 was straightforward. They could pay $75,000 to secure the required property interest and resolve the dispute permanently. Option 2 involved an ongoing mandatory easement arrangement carrying annual payments that would continue indefinitely. Neither option was attractive. During follow-up proceedings, Ryan's attorney tried to negotiate. He argued the amount was excessive. He argued that no actual damage occurred. He argued that the value exceeded the size of the land involved. The judge wasn't interested, because this case had never been about the square footage. It was about conduct. It was about choices. It was about ignoring warnings and assuming consequences wouldn't apply. At one point, the judge made a statement that everyone in the room seemed to remember. He said, "You had multiple opportunities to correct the problem before completion. You chose to proceed. The consequences of that decision belong to you." The room became very quiet after that. Madison started crying. Not dramatically. Not for sympathy. Just the kind of exhausted crying that happens when reality finally catches up with hope. Ryan looked completely defeated. For months they had convinced themselves that common sense would save them. That nobody would force meaningful consequences over 6 inches. That eventually I would settle. That eventually the court would compromise. Instead, they discovered something many people learned too late. Courts care a lot about property rights, especially when one party knowingly ignores them. A few weeks later, the payment was finalized. $75,000. Then came reimbursement for legal fees. Another $18,000. Then survey expenses, recording fees, easement documentation costs, administrative expenses. By the time everything was finished, the total exceeded $100,000. All because of a decision that could have been avoided near the beginning of construction. The really unbelievable part is that correcting the foundation when I first raised concerns would have cost only a fraction of that amount. Expensive? Sure. Painful? Absolutely. But nowhere near 6 figures. Every time I think back to those early conversations, I remember Ryan standing there with that phone in his hand, smiling confidently, telling me the property app said everything was fine. That moment ended up costing him more than $100,000. Not because technology failed. Not because the survey markers moved. Not because the law was unfair. It happened because pride convinced him that being challenged was worse than being wrong. And once that mindset takes over, even smart people can walk straight into disasters they had every opportunity to avoid. After everything was over, people kept asking me the same question. Was it worth it? Was 8 months of legal filings, hearings, phone calls, surveys, and stress really worth fighting over 6 inches of land? And honestly, I understand why people ask that. On the surface it sounds ridiculous. 6 inches doesn't sound like something worth going to court over. It doesn't sound like something worth damaging a relationship with your neighbors over. It certainly doesn't sound like something worth spending more than $100,000 over. But here's the thing. It was never actually about 6 inches. The land could have been 6 inches, 6 feet, or 60 feet. The size wasn't the issue. The issue was respect. When I first approached Ryan, I wasn't threatening him. I wasn't demanding money. I wasn't trying to create drama. I was giving him an opportunity. I was saying, hey, there's a problem. Let's fix it before it gets worse. Most reasonable people would at least investigate. Most reasonable people would pause construction long enough to verify the facts. Instead, he treated every warning like an inconvenience. Every piece of evidence became something to dismiss. Every opportunity to solve the issue became another reason to dig in deeper. This is a psychological trap that shows up everywhere in life, not just property disputes. Somebody makes a mistake, then invests so much pride into defending that mistake that admitting it becomes more painful than continuing it. The problem grows. The costs grow. The consequences grow. And eventually reality sends a bill. From a legal perspective, one of the biggest lessons from this entire situation is that courts often pay very close attention to behavior. People sometimes assume judges only look at outcomes. That's not always true. They also look at decisions. They look at warnings. They look at opportunities that were ignored. According to standard procedure, property disputes often become much more serious when one party knowingly proceeds after receiving notice. That's exactly what happened here. The house itself wasn't the reason they lost. Their response to the warnings was the reason they lost. Looking back now, I don't hate Ryan or Madison. I really don't. In fact, there are moments when I genuinely feel bad for them. They worked hard for that house. They invested enormous amounts of money into that dream. They imagined raising a family there and building a new life. But dreams don't exempt people from responsibility. Ownership matters. Boundaries matter. Actions matter. The lesson here is surprisingly simple. When somebody brings you a legitimate problem, don't automatically assume they're your enemy. Sometimes they're giving you the last cheap opportunity you'll ever get. Ignore that opportunity, and the next conversation might involve lawyers, judges, and numbers with far more zeros attached to them. So now I'm curious what you think. If you were in my position, would you have accepted the money and adjusted the property line? Or would you have fought the case all the way through like I did? And if you were in Ryan's position, at what point would you have stopped construction and fixed the mistake? Let me know down in the comments because these stories always divide people right down the middle. Some folks think property rights are absolute. Others think common sense should outweigh technical boundaries. Either way, one thing is certain. The most expensive 6 inches Ryan Keller ever ignored weren't part of his foundation. They were the 6 inches between his ears where common sense should have stepped in and stopped the disaster before it ever happened.